Good morning. Thank you for joining us for the July installment of the Environmental Essentials for In-House Counsel webinar, our monthly webinar series. My name is Christine Wyman. I'm a senior principal in the Policy Resolution Group. Together with Daniel Pope, an associate in the Environmental Strategy section, we'll be providing you an update on two significant Clean Water Act developments. First, I'll be speaking on EPA's issuance of its Section 401 regulations. Second, Daniel will provide an update on litigation surrounding EPA's Waters of the United States Rule, WOTUS. If you have any questions that arise during the presentation, please enter them in the box on the bottom right of your screen. If we have time at the end of the presentation, we will address your questions. Or otherwise, please feel free to email either Daniel or I, and we will respond to your email question directly. With that, let's get started. So the first topic that we're going to be discussing today is Clean Water Act Section 401. First, a few statutory basics. Section 401 gives states and certifying authorities the opportunity to certify whether discharges that arise from projects that require federal authorization will comply with applicable water quality requirements. It also allows for states to condition these certifications to ensure they will comply with the applicable water quality requirements, including any appropriate requirement of state law. Federal permits and authorizations cannot be issued and granted until or unless the certification is received or the certification requirement has been waived. The statute provides that the time period for a state's review of a water quality certification request begins with the receipt of the request for certification and extends for a reasonable period of time, although it's not to exceed 1 year from the date of the receipt. If more than a year has expired or a reasonable period of time has expired, Section 401 certification requirement is waived and the federal agency may proceed with issuing its authorization or permit. Section 401 has become a go-to tool of opponents of energy infrastructure projects. Both states and other organizations that seek to block or halt energy infrastructure projects have seen Section 401 as an opportunity to delay these projects. As such, the Trump administration has included reforming Section 401 and part of its reforms to energy infrastructure permitting that are intended to provide additional predictability and consistency for energy infrastructure permitting. In April of last year, President Trump signed an executive order that directed EPA and other federal agencies to look at their regulations and guidance, update them to ensure consistency with the statute, and provide alignment among the federal agencies in implementation of Section 401. EPA then took the step of withdrawing previously issued 401 guidance that was published in interim form that provided pretty expansive authority for states to review certification requests under Section 401. And also provided a platform for potential misuse of Section 401. In place of that interim guidance, EPA issued shorter guidance that more aligned with the statutory provisions of Section 401 that related to timing and scope of the Section 401 review. In August of last year, EPA then issued proposed regulations that for the first time provided a comprehensive framework for how federal agencies are supposed to be implementing Section 401. EPA just last month finalized that rule with minimal changes from the proposal that are intended to improve the durability and the implementation of Section 401. So now let's talk about the final rule. Today's final 401 rule replaces its original Section 401 regulations that were promulgated in the early 1970s. These regulations were nearly 50 years old, and they were promulgated to implement an earlier version of the Section 401 statute that was similar to, but differed from, the Section 401 statute as we know it in regard to several key terms. The original regulations also lacked specificity and guidance on the proper implementation of Section 401 and accommodated some of the misuse and abuse of Section 401 to oppose energy infrastructure. The new regulations that EPA has issued provide a comprehensive rewrite of the Section 401 regulations that are intended to provide a detailed process for implementation, a clarified scope of review, and define clear roles for the states and federal agencies in implementing Section 401. So with that, let's review some of these improvements, some of the new aspects of the Section 401 rules. First, on process. The final rule provides a clear process for the act of submitting a Section 401 request, in part to provide clarity on the time period by which a state or certifying authority has in which to review that request, and thus provide additional clarity on when waiver occurs. So the Section 401 process under the new final rule begins with the pre-filing meeting request by the project applicant, which must occur at least 30 days prior to submitting a request. This meeting provides an opportunity for all interested parties to discuss the scope of the certification request, the resources that might be needed to address the certification request, and any interesting or unique aspects of the Section 401 request to ensure that all parties are on the same page. The certifying authority or state does not need to accept a meeting or act on the pre-filing meeting request in any way, but the regulations do require that the project applicant request such meeting and provide that opportunity. The project applicant then makes the certification request. This, under the statute, is what triggers the reasonable period of time not to exceed 1 year for the state's review of the certification request. EPA's final rule provides clarity on what is the receipt of the request by providing for the first time a definition of a certification request. Under the rule, the certification request must include the contact information, identify the proposed project, any required federal authorizations, as well as include a description of any methods and means proposed to monitor the discharge and the equipment or measures planned to treat, control, or manage that discharge. It's important to note that this information is intended to serve as the request for the certification, but it does not limit the state's ability to request additional information. It's only the request for purposes of starting the time period, and it's supposed to be intended to provide the state sufficient information to begin the certification request evaluation. The project applicant also provides the certification request to the federal agency. This is in part to help the federal agency determine when the receipt of the request has occurred and thus establish the reasonable period of time and when waiver of the 401 request would occur. The federal agency is to determine the reasonable period of time within 15 days of the receipt of the request. They can set this time period either categorically or on a case-by-case basis. For example, the Army Corps of Engineers sets 60 days as the reasonable period of time for all Section 401 requests, but then provides an opportunity to request additional time not to exceed 1 year. EPA's new final 401 regulations also provide clarity on the scope of review of the Section 401 request, both related to the types of impacts that states can look at, as well as the discharges that trigger Section 401. So EPA's final rule first provides a statement on the scope of Section 401, and that is it's limited to assuring that a discharge from a federally licensed or permitted activity will comply with water quality requirements. Any action, therefore, purportedly to be taken under Section 401 must fall within this definition of scope. EPA then provides several definitions that help provide more clarity on what the scope entails. Importantly, EPA provides a definition of discharge that means the discharge must be from a point source into a water of the United States. This has been noted by some as limiting the scope of the Section 401 review to be limited to point source discharges, whereas previously some states and jurisdictions looked at upland impacts or upland activities and their potential downstream impacts, as well as non-point source discharges for triggering Section 401. EPA's final rule also provides a definition of what those appropriate water quality requirements are, and those are to be the enumerated provisions from the Clean Water Act that are identified in the statute, as well as state or tribal regulatory requirements for point source discharges into the United States. This provides states the opportunity to look at their state laws that are implementing water quality requirements for point source discharges and ensure that any potential discharge from a federally permitted activity will comply with those state laws. EPA here is using its authority to interpret ambiguous provisions of the statute in order to provide the single and consistent definition of the scope of review. This aspect of the rule also provides broader authority to the states than what was provided in the proposed rule, which had previously limited states to look at EPA-approved Clean Water Act regulatory program provisions in addition to those enumerated provisions. And so this response to states and others in their comments that were concerned that EPA's proposed rule unnecessarily limited the scope of water quality requirements that states could look to ensure compliance. Finally, the regulations address the balance of federal and state authority. And this is important because Section 401 has roles for both the federal agencies and the state water quality agencies. However, in the past, implementation and what the roles of each of these stakeholders has been implemented inconsistently. And so under the new regulations, the state is responsible for evaluating whether discharges comply with water quality requirements. In taking action under Section 401, they can issue denials or conditions, but they must point to the relevant provision that supports the condition or denial. And if more information is needed, the states need to identify what additional information is needed. And so in this instance, the states are really given the exclusive authority to look at the potential discharge and really evaluate and determine whether or not, in their best judgment, that discharge will comply with the applicable water quality requirements. But they also must substantiate those determinations and point to the relevant regulations or provisions that they are basing those determinations on. In contrast, the federal agencies really have the role of implementing Section 401 and ensuring compliance with the statute from a procedural standpoint. Here, the federal agency is responsible for setting the reasonable period of time, reviewing the 401 action for compliance for procedure, for example, ensuring that the state is identifying the applicable water quality provisions that a condition is supporting. And also the federal agency is tasked with determining whether a waiver of the 401 obligation has occurred. This might occur because, for example, the state takes no action during the reasonable period of time, or the state might take action that does not procedurally meet the requirements of Section 401, and in which case waiver could occur in that instance as well. It's important, one of the additional topics that this regulation addresses is whether or not federal agencies can address conditions individually, or whether or not they have to take the state action as a whole. Regulations do allow for the federal agency to look at specific conditions in a certification, and if those conditions individually do not meet the procedural requirements of the 401 regulations, the federal agency can exclude that condition on its own from being incorporated into the federal authorization. So what are the next steps for Section 401? Well, we do have a final rule, and it's intended to improve predictability and consistency for the process. That's to be applicable to projects that are seeking individual Section 401 certifications. So, for example, a project that the project applicant submits the certification request, the timing and the scope procedures are intended to provide certainty as to the process, the timing of the process, and when they can expect a clear response from the state on whether or not the certification is granted or denied. But Section 401 also applies to general permits that are issued, for example, by the Army Corps of Engineers. These types of projects will also require Section 401 certification, and these new regulations will hopefully provide some more consistency and predictability on how states are certifying those general type permits, including the scope of a state's denial or conditions that are imposed on those Section 401 certifications for general permits. Federal agencies are also supposed to be looking at EPA's new regulations and reviewing their own 401 regulations and ensuring alignment and consistency. And so I expect that we'll see some rulemakings coming from possibly the Army Corps of Engineers and other agencies that routinely implement Section 401 to ensure that their regulations are consistent with the EPA regulations. We also expect there to be litigation surrounding the final rule. There's significant opposition over the final rule or over the Section 401 reforms in general from Democratic state attorneys general as well as environmental groups. The litigation and the concepts that this litigation is addressing is likely to move past just the nuts and bolts of Section 401 and really grapple with some key issues that EPA had to deal with in implementing these regulations, dealing with changed interpretations, an agency's ability to interpret ambiguous provisions of a statute, and the really tricky issue of what is the appropriate balance of authority between state and federal agencies. So that is what we expect to come. With that, I will turn it over to Daniel Pope to talk about the new Waters of the United States rule.
Thanks, Christine, and thank you for being with us this morning. Today, we're going to take another look at litigation over the 2020 WOTUS rule. If you were able to attend our virtual seminar in the spring, I previewed some of the arguments we expected to hear about the new rule. As a brief reminder, in 2019, the current administration repealed the 2015 Clean Water Rule, which had only had a limited effect. And in 2020, and earlier this year, the administration finalized its Navigable Waters Protection Rule. To summarize the rule, the administration tried to create clear categories that would make the Clean Water Act's jurisdiction more predictable and manageable. And that was a shift from the 2015 rule, which frequently used scientifically demonstrable hydrological connections to support jurisdiction. And for that reason, the 2015 rule was really controversial. If you want to know more about the new rules approach, please reach out to me and I'll point you to some of the resources we've developed on the rule itself. But today we're going to talk about litigation, and we're going to talk about three things. First, where we are today with WOTUS and the two lawsuits that have reached the preliminary injunction decision stage. Second, what are some of the arguments being made in other lawsuits around the country? And third, and to close us out, I'll offer some broader thoughts on what's next for WOTUS and what might be needed to stop the constant litigation over the definition. So first, where are we today with the WOTUS rule? The 2020 Navigable Waters Protection Rule is in effect in every state except for Colorado. The rule went into effect last month on June 22nd, but don't go shredding your discharge permit just yet. It's going to take some time for the agencies and their districts and regional offices to revise existing procedures and develop new ones. And of course, the agencies will need to redraw more than a few maps. And litigation will need to be resolved as well. The first major lawsuit against the 2020 rule, California versus Wheeler, resulted in an early and significant victory for the agencies. A number of states led by California and New York sought to enjoin the rule's application with a nationwide preliminary injunction. And Judge Seaborg of the Northern District of California denied that request. You should expect to see Judge Seaborg's rationale, which we'll discuss here in a second, show up in multiple lawsuits as the government pushes back on arguments for both preliminary and permanent relief. California versus Wheeler nicely demonstrates a lot of the arguments that we're going to see in multiple courts. First, plaintiffs argued that the 2020 rule improperly relies on the opinion in Rapanos, which had emphasized a continuous surface connection to navigable waters as the basis for Clean Water Act jurisdiction. While a common approach to the fragmented opinion in Rapanos has involved an effort to account for both the plurality and Justice Kennedy's significant nexus concurrence, and that's something I expect the government to argue that the rule does, the states in California versus Wheeler said that the plurality opinion was rejected by 5 justices on the Supreme Court, and Justice Kennedy's rationale should govern. Second, plaintiffs emphasized just how important certain waters are that would be outside Clean Water Act protections under the new rule. For example, these waters perform a number of ecosystem services and have scientifically measurable effects on downstream water quality. The plaintiffs also argue that many states are currently unable to effectively prevent pollution of these now non-jurisdictional waters that would lose Clean Water Act protections. I'll just note here that plaintiffs are bringing very scientifically oriented challenges to the rule. And you may have already seen, for example, that EPA's own scientific advisory board had been critical of the new rule. Plaintiffs are also arguing that the government is taking a position here in the 2020 rule that's contrary to many of its previous factual findings, including, for example, the 2015 connectivity report that undergirded the 2015 WOTUS rule. So in California v. Wheeler, the state's motion for preliminary injunction was denied, primarily on the first prong of the preliminary injunction analysis, which requires the movement to show that it's likely to succeed on the merits of its argument. Judge Seaborg issued his order on June 19, the Friday before the rule went into effect. And I think his order is very good, and if you're interested in the area of law, I'd commend his opinion to you. After a long 3.5-hour hearing the day before, Judge Seaborg made the following observations. First, there's no real precedent for these kinds of cases because the previous Supreme Court litigation focused on whether the agencies had gone too far in asserting Clean Water Act jurisdiction. Here, the plaintiffs are arguing that the rule hasn't gone far enough. Second, Judge said that there's no Rapanos mystery majority that categorically rejected the pluralities approach. The dissenters in Rapanos and Kennedy disagreed with the plurality's reasoning for why the rule was unlawful. But per Marks versus United States, a Supreme Court case from the 70s, a court's supposed to make sense of a fractured decision by construing the holding of those who agreed and the judgment on the narrowest grounds. Other rationales don't matter. I think the government is going to draw on Judge Seaborg's use of Marks here and their other lawsuits to support their reliance on both the Rapanos plurality and Justice Kennedy's concurrence in that case. Judge Seaborg also held that Chevron deference applies and that it's entirely fair for an agency to change policies as long as those policies are consistent with the statute and applicable laws. The California plaintiffs had also raised concerns about the workability of distinguishing between ephemeral and intermittent flows. You may recall that ephemerally flowing streams are categorically excluded from jurisdiction under the new rule. The plaintiffs also claimed that a typical year is inadequately defined. The judge did seem open to these arguments about the administrability of the rule, but he concluded that these issues, standing alone, were not sufficient to warrant a preliminary injunction. On irreparable harm, Judge Seaborg did seem to side with the plaintiffs and conclude that there might be some potentially immediate and irreparable harms. And if plaintiffs had made a better showing on the merits, the identified harms might support a preliminary injunction to maintain the status quo. While the decision on the whole is adverse to those challenging the rule, I'd expect advocates to try to distinguish their case from the state's case and point out that Judge Seaborg thought there might be real harms to the implementation of the rule. The outcome in California, though, was different, with an injunction as to the 2020 rules application in that state just coming a few hours after the decision from Judge Seaborg. It's a peculiar decision with a number of features I expect will be raised on appeal. The court grappled with what kinds of harms Colorado would suffer and ultimately concluded that the costs of having to rapidly assume enforcement responsibilities constituted harm. What's curious about the Colorado court's analysis on irreparable harm is that the court spent most of its time talking about standing. And those harms are different from the kinds of harms that are needed to relief or preliminary. But once the Colorado court concluded that the state had standing, it concluded almost without discussion that irreparable harm had been demonstrated. I expect to see that on appeal. The Colorado court also frequently stated that it's unclear what Rapanos is for, but it's clear what it is against, the plurality's interpretation of WOTUS. But that's the specific position that Judge Seaborg disagreed with, and there's no citation to Marks in the California decision. So it'll be interesting to see what kind of arguments that the government is going to make on its appeal. We don't have time to look at every single pending challenge to the new rule, so I've selected a few that are indicative of additional arguments that we're likely to see. As these cases exit the preliminary stage, we're going to see plaintiffs digging deeply into the administrative record to find examples of arbitrary and capricious rulemaking and decision-making. Plaintiffs might also try to exploit differences between the proposed rule and the final rule to identify procedural flaws under the APA. We might also see challenges on procedural requirements from other statutes, for example, like Endangered Species Act, Section 7. In Conservation Law Foundation versus EPA, the plaintiffs are arguing that the new rule is inconsistent with the statute. That's our mystery majority of Rapanos argument again. They're also arguing under the APA that it's arbitrary and capricious because the rule ignored the Scientific Advisory Board's conclusion that this rule was inconsistent with science. It's also arbitrary and capricious per the plaintiffs in Conservation Law Foundation that because the rule fails to adequately explain certain provisions of the rule. There's a leitmotif throughout the complaint and many others, frankly, and that is hostility to the current administration. Expect to see those kinds of arguments also throughout other forms of litigation. And Puget Soundkeeper versus EPA, the plaintiffs make many of the same arguments as the Conservation Law Foundation about the inconsistency of the rule with the Clean Water Act's purpose and its inconsistency with scientific conclusions about hydrological connections between water bodies. What makes Puget Soundkeeper a little more interesting, though, is that it attacks both the 2020 Navigable Waters Protection Rule and the 2019 Repeal Rule, which struck the 2015 Clean Water Rule off the books. For a brief moment there, we were regulated under 1986 Waters of the United States regulations as modified by Swank and Rapanos. The 2020 rule replaced those resurrected 1986 regs, and presumably those background regulations are in place in Colorado. But a few states have challenged the 2019 repeal rule directly, and many of those suits have either been dismissed or amended into complaints that target both the 2020 rule and the 2019 repeal rule. A few of those, like Puget Soundkeeper, asked that the 2015 rule be reinstated as part of the relief sought by plaintiffs. That seems dramatic and improbable to me, but we'll have to find out how those lawsuits develop and if the extremely nightmarish scenario of the 1986 rule, the 2015 rule, and the 2020 rule all being in effect at the same time ever develops. The next case is Environmental Integrity Project versus Wheeler in DC. This was somewhat like the other lawsuits we've discussed, with a really interesting twist. EIP argues that the Supreme Court's recent decision in County of Maui versus Hawaii Wildlife Fund expresses the court's disagreement with EPA's position. In that opinion, the Supreme Court concluded that discharge from a point source to a WOTUS required a permit, even if the discharge passed through groundwater first before reaching the WOTUS. The key phrase, as I'm sure many of you know by now, is that a permit is required when there is a direct discharge to a WOTUS or a functional equivalent of a discharge. EIP essentially argues that Maui is an endorsement of hydrology-based jurisdiction. EIP also points out that the court was concerned that excluding discharges via groundwater would create loopholes that would frustrate the statutory purpose of the Clean Water Act. Expect to see additional citations to that argument as we get into the briefs and motions for summary judgment on the WOTUS rulemaking. Additionally, EIP also brings up something I've been thinking about since Maui. Justice Breyer said in dicta that the court did not plan on deferring to EPA's interpretation of the term discharge because EPA had changed its position several times with respect to discharges to WOTUS via groundwater. EIP may also try to argue that Chevron deference to agency interpretations of waters of the United States shouldn't apply. I'll be watching to see how that argument develops. Another interesting case is New Mexico Cattle Growers Association versus EPA. And this is a challenge brought by a libertarian and conservative advocacy organization. The Pacific Legal Foundation is representing the New Mexico Cattle Growers Association in this litigation. And the New Mexico Cattle Growers Association was hoping not to be burdened with WOTUS compliance at all in 2020, but it remains included under the new rule. PLF before has had some significant successes obtaining judicial review for preliminary determinations of the jurisdiction under the Clean Water Act or enforcement orders under the Clean Water Act. You may recall the Sackett and Hawks cases. But PLF's challenge here is not technical like those challenges were. It's attacking the new WOTUS rule on the, in my view, dramatic claim that it extends beyond navigable and fact waters at all. The PLF argues that jurisdiction under the Clean Water Act is limited to navigable and fact waters used in commerce. So recall what the new rule does. It categorically includes all tributaries to traditionally navigable waterways. But PLF argues that that's an ultra-virus form of regulation. Those tributaries need to be evaluated as to whether they are navigable in fact. You may recall that the Rapanos plurality acknowledged this argument in earlier WOTUS cases and actually dismissed it. In Riverside Bayview and Swank, and this is something also cited in Rapanos, the court concluded that the definition of navigable waters as the, quote, waters of the United States meant that there was something extra beyond navigability. In fact, that's the basis of Clean Water Act jurisdiction with respect to a particular water body. One thing that's interesting to note is that there's a companion case to New Mexico cattle growers, case brought in Oregon called Oregon Cattlemen's Association. This one's argued by the Pacific Legal Foundation as well, but Columbia Riverkeeper has intervened on the side of the government. So what's next? Over the next year, we're going to see a lot of activity in this area. We might see more preliminary injunction fights, maybe some requests for nationwide injunctions, motions for summary judgment, normal garden variety appeals, emergency appeals. We might eventually see a Supreme Court opinion, and one that would hopefully speak with a 5-person majority at the minimum, so that the agencies and the regulated community would be freed from the obligation to read the Rapanos tea leaves. As you see from every complaint against this rule, the dispute over what Rapanos actually means continues to be a significant interpretive problem for the Clean Water Act. Now, there's already plenty to follow, but with the possibility of a change in administration, we see an entirely new set of questions. What posture would a Biden administration take towards the rule? Would it begin a new rulemaking to add new categories of jurisdiction? Would it vigorously defend the rule through tenacious litigation and appellate work, or simply shrug as the rule is enjoyed in a state or circuit? One thing is for sure, you need to be following our policy resolution group, and you should check out Pulse, which has excellent election coverage. One thing does seem highly unlikely, though, whatever the odds of other outcomes are. I highly doubt that Congress will take up these kinds of nuanced policy questions regarding the jurisdiction of the Clean Water Act, or otherwise provide some kind of statutory clarity on the definition of navigable waters and waters of the United States. And because it won't, the litigation over the geographic reach of the Clean Water Act will continue to be perennial. But long-term uncertainty isn't anything new for those of you who have been following WOTUS for any stretch of time. If you do have any questions about the rule in the meantime, or lawsuits over it, please reach out to us. And thank you for being with us this morning. Please stay safe and reach out to Christine or me if you have any questions about what we covered today. We're taking a break for the month of August, but we'll be back in September with a presentation on ESG. Stay tuned for additional information on that topic, and thank you for being with us this morning.